Guy DiMartino. Good evening. I'm a Northwest Indiana estate planning and probate lawyer. And the other day I was meeting with a couple who was putting together their wills, and they had a couple of children, and they were all about coming off and being fair to their children. And this is the question that they asked when it came time to being a personal representative. Of course, typically when a husband and wife put together their will, they make each other their personal representatives should one predecease or when one is going to predecease the other. But then came the question of alternate or contingent personal representatives or successor personal representatives. The personal representative that would handle the estate once the second spouse passed away. And one of the parents said, "Can we name both of them? We want to be fair. Is it okay to have more than one personal representative?" And the answer to that question is yes, you can have co-personal representatives, but in my view, and based on what I've seen over the years, I would never have more than two. You see, you need somebody to take control. You need somebody to go out and do the work that needs to be done. And if you have more than two personal representatives, then they start having to do things by committee. And then what happens if two people want to do something and one person doesn't want to do something? For instance, sell a piece of property or sell some stock or things along those lines. So if you have three co-personal representatives or three personal representatives at the same time, that can definitely lead to a problem and end up causing some type of problem between the family or between the personal representatives, and there will be hard feelings. So the answer to the spouse's question was, yes, you can have both your kids, especially since both your kids are going to be the only heirs at this time that'll take under the will. So everything that you leave for them as of the last and standing spouse is going to be split up between both of them 50-50. So there's really no issue with them being co-personal representatives unless one was out of the country or lived someplace very far away, but they can always allow the other person who lives in the area to handle the estate. If you have any questions about a Northwest Indiana estate planning or probate matter, you can always give me a call. I am Guy DiMartino. Have yourself a great day.